in every single case, and then we'll just send them the lines that they have. All right. Once Mr. Hicks is settled, let's bring him in. Okay. Everybody's here? Okay. All right, if I call your name, please come on up, and the deputy will instruct you where to sit. Gary Johnson. I thought we were missing someone. Oh, no, you were sitting down. You were hiding under the chair. Very good, Mr. Johnson. Come on up. Mary Touchton. Susan Kajowski. Elizabeth Leverdur. Andrew Kellogg. Donald Rice. Followed by Anthony Perkins.
No, come around. Okay.
Oh, Deputy, are they good to go also?
Yes, they are.
Okay.
Perfect.
So, and by they, I mean the panel.
Yeah.
Okay, very good. All right, so, members of the jury panel, I wish to thank you for your hard work and time and attention today. We couldn't do without you. There is a, I'll say this every time until we stop doing this. There's a judge on this hallway who every time, for every jury case, once we get to this part, says, all right, please report down to jury services, and then everyone leaves with a groan. And they're almost all the way gone. It's just, oh, just kidding, you're free to go. I'm not going to do that to you. I am going to tell you you are free to go today. So I wish to thank you for your time. Again, you are happy to go about the remainder of your day without any further obligations here. And as I always say, if your boss has asked, you were here till midnight, okay? Thank you. You're free to go. Oh, we do need the headphones back, though, unfortunately. They're good, though. I know. We paid for them with tax dollars, but you just hand those to the deputy on your way out, ma'am.
Yes.
Did you get them? Did you get them?
Yeah.
That's something, right? All right, now, all selections have been made, so sworn. Members of the jury, if you could please stand to be sworn. And raise your right hand.
Do you solemnly swear that the witnesses I am so sorry, that is incorrect. Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant whom you shall have in charge, and a true verdict rendered according to the law and the evidence, so help you?
I think you can be seated. I have some instructions. I said you're going to get a lunch break, and you will, but there are some instructions I need to go over. You have been selected and sworn as the jury to try the case of the state of Florida versus Jacob Hicks. This is a criminal case. Jacob Hicks is charged with trespass on property other than structure or conveyance. Excuse me. The definition of trespass on property other than structure or conveyance will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Jacob Hicks in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys of Mr. Hicks will have an opportunity, if they wish, to make an opening statement. The opening statement will give the parties a chance to tell you what evidence they believe will be presented during the trial. What the parties say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the parties. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. After the evidence has been presented, the parties will have the opportunity to make their closing arguments. Following the arguments by the parties, the court will instruct you on the law applicable to the case. After the instructions are given, the alternate juror will be released, and you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the parties, and the instruction on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses during which you will be permitted to separate and go about your personal affairs. During these recesses, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask him or her to stop. If he or she persists, leave him or her at once and immediately report the matter to the deputy, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You must remove your watch, your smartwatch, and place it in a purse, bag, or pocket. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phones or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number can be provided upon request. The case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in the case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, The trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present arguments with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity are judicial system consequences. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. And this trial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court or face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters of law and other matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of this case. A couple other things. You now have special powers. Those red badges give you the ability to be invisible to anyone here in this courtroom who is not a deputy. So if you see the state, Mr. Hicks, or anyone else involved in this courtroom in the hallways, they will go at great lengths to avoid any contact with you, and that's by special instruction from me. It's so that there's any allegation of impropriety, trying to curry favor, or so on. So if you see any of the parties in the hallway and they ignore you, which they should be doing, then don't think that they're being rude. It's more just an instruction by me. Additionally, you are allowed to tell your friends or friends, I should say your family members, anyone that you have to talk about that you're here today, that you've been selected to be on the jury, but you cannot talk about what the facts are or anything that's been going on just yet. There'll be plenty of time for that once you're discharged, just to be clear. Additionally, you don't know any of the facts of the case, but we're here together, you know what the charge is. While we're on break, do not discuss the facts or the allegations or anything along those lines with your fellow jurors. You can talk about the weather, you can talk about anything you want other than this case. Again, that time will come later. I will give you an hour for a lunch break, so where to go? I know that people from all over the county, all over the county I should say. There is a place close by, they don't pay me any royalties for it, but it's right around the corner called Mike's Pizza and Subs. They have pizza and subs, right? And they can get you in pretty quick. There's a cafeteria down here. Mike's Pizza and Subs is around the corner. There's also fast food places up and down Overton. If you need any more recommendations, the deputies work here. I assure you that you can ask them and they'll have some advice for you. It is 12:20. I'll give you time to get to your cars if need be. We'll say we'll bring you back at 1:25, so please be back by then. You are allowed to bring drinks back into the courtroom if you wish. Okay? And with that being said, please follow the deputy's instructions from here on out. All right, thank you, Deputy. Would you be so kind? I'll just send you my copy of the jury instructions so you can read them over. Print additional ones. There you have it. Anything else we need to discuss from the state? Mr. Hicks, anything else we need to discuss before we take a break?
Yes, I just wanted to, even though I did say I forgive you, I've already forgiven you and the Sixth Circuit for that matter.
Okay.
I do think it is important you find a way to tell the truth about this issue.
Okay. Well, I mean, there's nothing for me to discuss. My whole role from here on out is to instruct on the law.
I'm just referring to the truth about your part in these proceedings.
Well,
But that's a moral concern,
Yeah.
one that's not subject to anyone's review but God.
Well, but I do want to bring up something, because I got thick skin, I can take it, Mr. Hicks, when you say something to me, that's fine. But what, and out of the presence of the jury, again, we'll deal with that. But you are not to disparage personally the state or me in front of the jury. You can.
Why do you believe I would do that?
Just because of what you said in the past.
Such as?
Well, I mean, complicit well, anything about me shouldn't go before the jury. I know you've had feelings, you forgive me, that's all well and good.
That is why I did state that I forgive you. I want you to know that, and I don't want you to be insecure about me exposing your behavior.
That's fine, but not to the jury, is what I'm getting at.
Again, I don't want you to be insecure about me exposing your behavior to the jury.
Well,
I respect your authority that God has given you over this courtroom.
And I appreciate it, but I just want to be clear.
Yes.
That you are not allowed to disparage the court.
I'm a man of integrity.
Okay, that's good.
And
That's
I deliberately want to encourage you to do the right thing. That's what that is. It's not disparaging. It's encouraging.
right.
Yes. So, with that said, I understand your concern.
Okay.
You won't have to deal with. You won't have that. I won't be. I won't be. In fact, I'll leave that to God.
Okay, that's fine. Again, whatever you want to say outside of the presence of the jury, I'm happy to hear it. In front of the jury is what we're talking about. All right, anything else before we take a break?
No,
You said no, and then, all right, so Mr. Hicks again, beat me back here just a couple minutes early, 12:20 is probably good. And I think that's what I meant to say, 1:20. Mr. Hicks, we also discussed that Mr. Montrone, as standby counsel, has a hearing he has to attend to at 2 o'clock, which will be in the break and back for the state also. We're going to have a hard break at 2. That's usually 15 minutes, give or take.
Yes.
Right, so, just in terms of the timing of it. Again, I'm giving you a copy of the jury instructions, Mr. Hicks. I'm gonna try and work on that trespass one to pare it down, because a lot of it doesn't apply, over the lunch break here, because it just doesn't. It's not a construction site and that kind of thing. That being said, I'm gonna clear to you have a break form, so I might as well talk about that right now.
Yes, Your Honor.
All right, and, Mr. Hicks and the state, can you approach, please? This is the standardized voting form that's been printed up by the clerk of the court, giving the suggestion the formatting of that from the state.
Not from the state, Your Honor.
Mr. Hicks, any objection to the verdict form itself? That's what we'll go back to the jury.
I don't see anything that I would think you would take me seriously about.
Okay, fair enough. Well, hearing no argument. There you have it. Again, Mr. Montrone is available if you want to speak with him. And you can.
I wanted to speak to him before the day of trial, but you made certain that he doesn't have to.
No, that's not true.
Yes,
he
you
made
did.
it clear.
You did. You made it clear that nobody has to contact me before.
No, in fact, what happened, what we talked about is that I said, give him the contact information, we tried to get you, and Mr. Montrone put on the record before. That being said, we got this lunch break here. But
This is after 13 pre-trials. He's asking for my contact information as if he didn't have it, as if the court didn't have it, Your Honor.
well, I mean, it's,
I know.
But-
You know that none of the attorneys that have attempted to represent me have communicated in a basic form. You know that I just got the evidence that the state gave to the attorney who had on standby. All I'm saying is that we've been through this.
Okay. And just along those lines, I told you have to ask this at every critical stage of the trial, so I'm gonna ask you again, just because the Florida Supreme Court says I have to. Not just because, it's an
Yes,
important.
but the courts say you also got to protect my religious freedoms.
I get it,
You
but after
allow
this
the
question-
state to run roughshod right over them.
As to this question, do you still wish to continue to represent yourself as we go into openings and evidence by the state?
I must, and yes, I have to. I'm not going to allow any of the attorneys that you insisted misrepresent me.
Okay, and just to be clear, I'll be asking that at other times during critical stages of the trial, so in case it's not like a broken record, Mr. Hicks, I have to ask that. So, Mr. Montrone is available if he has any questions, is that right, Mr. Montrone, during this lunch break?
Yeah, I'll give him my phone, and he can call me.
Actually, there's a reason why.
You don't have to if you don't want to, I'm just saying he's there if you need him.
If he wants to communicate, he could have asked for my contact information. In fact, as you, my number has not changed in 10 years. In fact, it's the same number that I've spoken to the public defenders on. It's the one that's in the case file that was passed to Mr. Pingor, your colleague. So
Okay.
there's no reason why
I was thinking
why
there's
you
no
would be
attorney
just
class
now
there.
saying, oh, I couldn't get in touch with Mr. Hicks.
So that means.
In fact, you would be
recess till
admitting that you
1:25.
haven't done your due diligence. If the day of trial, you're just now asking for contact information. So I don't want to,
I'll say 1:20.
Okay,
Sorry.
good.
Where's the recess till 1:20? Okay. Now, I will say, since we're into the 3/5 comment, because it's actually not 3/5.
Actually, I don't want to go back and forth about that.
I'm just saying it's zero,
I,
it's not 3/5.
I don't want to go back and forth about something that's irrelevant.
Well, that's true. I agree with
That's
you.
right.
As a student of
Spare
history,
me,
though,
spare me.
it was a interesting.
I get
so
it,
that
Your
the
Honor.
southern states
I
get
get it. I
more
understand,
representation
Your
while
Honor.
depriving people of rights.
I understand.
Terrible thing.
I understand, but none of that's relevant
I agree.
to today's proceedings.
I agree.
And I question why you're trying to shove that down my throat.
I'm not actually engaging in discussion about what it actually was.
Why?
Because you brought it up.
Thank you, Your Honor.
You're welcome.
But it's irrelevant.
It is irrelevant.
Oh, you made it.